Welcome to our YouTube channel. This is C&V Advisory, and today we'll be discussing what you need to know about the dissolution of marriage in Nigeria. So if you've not subscribed already, this is the best time to click the subscribe button below right now. So without wasting any of your time, let's get into it right away. So we'll be talking about the types of marriage, because the procedure for how to dissolve a marriage in Nigeria is dependent on the type of marriage contracted. So the following are the types of marriage in Nigeria. The first one I'll be talking about is customary marriage. This is a union of a man and a woman, or more than one woman. It also involves two families. Nigeria has many types of customary marriages, as diverse as the country's numerous cultures. So these are the core features of customary marriage. The first one is the parents' consent, and the consent of the parties to the marriage and age. Then the second one is bride price or dowry, prohibited degrees of affinity and capacity to marry under customary law. So the second one is statutory marriage. A statutory marriage is a voluntary union for life of one man and one woman to the exclusion of others. In other words, a statutory marriage is monogamous marriage. Examples include marriage done at the court registry, marriage done in licensed places of worship such as churches. The principal legislation regulating statutory marriage in Nigeria include the Marriage Act, the Matrimonial Causes Act, Cap M7, Laws of the Federation of Nigeria 2004. The matrimonial causes rules made pursuant to the Matrimonial Causes Act. So the third one is Islamic marriage. Islamic marriage, like customary marriage, is essentially polygamous. So if the man wants, he can marry up to 4 wives. It has most of the characteristics of the customary marriage as discussed earlier. So the principal requirement of a valid Islamic law marriage is the consent of the parties, parental consent, then payment of the sadakat, that's the bride price or the dowry, then solemnization. So that's it. So let's talk about how to dissolve a marriage in Nigeria. The first one I'll be talking about is how to dissolve a statutory marriage in Nigeria. A statutory marriage can only be dissolved by a state high court in Nigeria. The process for how to dissolve a marriage in Nigeria starts by filing a petition in the court. So you have to file a petition in the court to start with. Then in order to dissolve the legal marriage, the court must be satisfied with the unsuccessful settlement option. Then the dissolution by court must be on ground of an irretrievable breakdown of the marriage. Section 15B of the Matrimonial Causes Act stipulates the meaning of irretrievable breakdown of marriage, in which the law stipulates that the courts can only determine that the marriage has irretrievably broken down in one or more of the following facts or grounds. So let me state the facts and the grounds right now. The first one, that the respondent willingly refused to consummate the marriage. The second one, that since the marriage, the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. Then the third one, that the respondent has believed in a way that the petitioner cannot be reasonably expected to live with the respondent. Then the fourth one, that the respondent has deserted the petitioner for a continuous period of time, or at least 1 year preceding the petition. Then the next one is that the parties have lived apart for a continuous period of at least 2 years preceding the petition, and the respondent does not object to a decree of dissolution being granted. Then the next one, that the parties to the marriage have lived apart for a continuous period of at least 3 years preceding the presentation of the petition. The next one is that the other party to the marriage for a period of not less than 1 year failed to comply with a decree of restitution from conjugal rights made under the Act. Then the last but not the least, that the other party to the marriage has been absent from the petitioner for such a time, and in such circumstances, the petitioner has to provide reasonable ground for the presuming that he or she is dead, which should be within 7 years. The proceeding for the dissolution of marriage is usually instituted by way of petition filed by the person bringing the action called the petitioner, and the party against whom it is brought called the respondent. These are the content of the petition. So this is what the petition contains. The first one, the petition or suit number. That's the parties and the status, the full name, the occupation, and the address of each of the party to the proceeding. Then the next one is the name of the wife immediately before marriage, particulars of the marriage, particulars of births of the parties to the marriage, and particulars relating to domicile or residence of the marriage in Nigeria. Then the third one is the particulars of cohabitation of the parties to the marriage and its season, particulars of children of the parties to the marriage and the children of either party to the marriage, particulars of previous proceedings between the parties to the marriage, if applicable, and facts relied upon but not evidence by which the facts are to be proved, facts to support the grant. Then the next one is condonation and collusion, proposed arrangement for children, custody, maintenance, settlement of property, reliefs being sought, and address for service on respondents. So the petition shall also be accompanied with other processes such as notice of petition, acknowledgement of service, verifying affidavits, certificates relating to reconciliation, and original marriage certificate. So the respondent, in response to the petition, files an answer or cross petition. The petitioner may in response file a reply to the answer or an answer to the cross petition, as the case may be. Upon the close of pleading, the parties move to the trial stage, where each party will be given an account of his or her experience in the marriage. Then the next stage is the adoption of final written address by the party's legal practitioner, and finally judgment. It is worthy of note that unless the leave of the court is obtained, no petition for dissolution of marriage may be filed within 2 years from the date of marriage. So before the court approves the dissolution, the court will consider other issues such as property jointly owned by parties, custody and maintenance of the children of the marriage. Then upon the dissolution of the marriage by the court then issues a decree, which is called a decree nisi, which shall become absolute after 3 months, except where there is a valid appeal against a decree nisi. It will not become absolute except the expiration of a period of 28 days from the day on which the appeal is determined and discontinued. Then where there are children of the marriage under the age of 16 years at the date of the decree nisi, the decree shall not become absolute unless the court is satisfied that the proper arrangements have been made for the welfare of the children. In appropriate cases, the advancement and education of the children are also put into consideration. So otherwise, the court must be satisfied that there are special circumstances that warrant the decree nisi being made absolute. Also, a decree nisi might be rescinded by the courts at any time before the decree becomes absolute. So these are the grounds upon which a decree nisi may be rescinded: upon the application of either of the parties to the marriage on the ground of that the parties has been reconciled. Then the second one is on the application of a party to the proceedings. If the court is satisfied that there has been miscarriage of justice by reason of fraud, perjury, suppression of evidence, or any circumstances. Then the third one is where an intervention takes place by the Attorney General or other persons after a decree nisi has been made. The court may rescind the decree if it's proven that the petitioner has been guilty. So now let's talk about the dissolution of customary marriage and Islamic marriage. Unlike the statutory marriage that can only be dissolved in High Court, the customary and Islamic marriage may only be dissolved at the customary courts. That's the difference. So at the customary court, a petition for dissolution of marriage will be filed accompanied by an affidavit stating that the marriage sought to be dissolved and was conducted under native customary law. So once the petition has been filed, the same shall be served on the respondent before the court can proceed to hear the matter. So apart from the solving of the marriage, the customary court also has the power to make an order for custody of children and other maintenance or child support. Then apart from the Islamic marriage, a Christian marriage conducted in an unlicensed worship center may also be dissolved in the customary court, since same is not qualified as a statutory marriage. Then the customary court proceedings are usually governed by the customary law of a particular state. In order for the dissolution of marriage to be successful in Nigeria, the petitioner must bring his or her petition in line with the grounds stipulated in the marriage proceedings law and must meet the requirements of the law. So you can drop your questions in the comment section right now, and if you've not subscribed already, do that right now. So you can drop your questions. Remember to like, share for people that actually need this information right now. Remember to share right now. So share, like, turn on your notification bell, and subsequently we'll be talking about more. So see you some other time. Bye.